Assalamu alaikum and welcome back to Hilaal Live. From the Cape Town studios, I'll be keeping you company until about 6:15 around there, and then the Johannesburg team takes over for Faraz Patel and the awesome team in Johannesburg until about 7:30, inshallah. Back on Hilaal Live, as I mentioned before the break, Advocate Yusuf Khan Dalwai back in studio. Assalamu alaikum.
Walaikum salam, Luqman, to you and your viewers as well.
Jazakallah so much. It's been a busy couple of weeks for us all. You've been traveling. We've had a lot of other topics to cover as well. But September was Wills Month. And, you know, we saw it quite a lot on social media. Some of the banks, insurance companies, all of that got involved advertising that and highlighting the fact that we need to have a will. You know, I know from personal experience of family members that didn't have a will and the complications that's caused. But to better understand, and we're going to open up the WhatsApp line for our viewers as well, if they'd like to ask any questions with regards to drawing up a will, they can do so 079 085 2511. But in terms of, you know, having a will and how the legal system looks at what a will can do and should do, maybe give us some background there.
Okay, firstly, before we go into detail regarding what it can and should do, we need to understand what this document is all about, right? And why it's called a will. So the moment you've done some estate planning in your life, you know, now you know what your assets are, and you know how many children you have, how many heirs you have, and who you would like to donate to. That needs to be in writing. Now that document becomes a legal document, in respect of how your estate is distributed.
Gotcha.
So that is extremely important, that once you completed your estate planning, and that meaning that you now need to take it to the next level, and that is reduce it in writing.
And it's basically a document to talk for you, to speak on your behalf in the event that you're no longer here.
Yes, like they say, you cannot rule from the grave.
Correct. Yes, I've heard that.
However, this document makes it easy for you to rest in peace. And your asset list that you have is distributed according to your wishes, and your family has been taken care of.
And sometimes maybe not everybody agrees the way it's been distributed, your estate's been distributed. However, that's a legal binding document that gets put through the legal system so that the assets can be divided.
Yes, so that's a legal document, like I said, can be executed. It only becomes active at the time or at the date of your death, and then your will is your
last
living testimony.
Gotcha. Now, where should this be stored? I mean, you get so before we get there, right? Chat to us about all the different information that needs to be relevant in a will.
Okay, now this is very important. So the Wills Act makes provision for what the formalities are. Okay, it's important. It's not about writing it on a piece of paper, or just pulling up a Word spreadsheet, Excel document, and putting asset 1 goes to my daughter, asset 3 goes to the masjid, asset 4 goes to my son. You know, it's not about listing your assets. Just you have to. A will is valid once it's complied with the formalities. Now, what is very important is that the will must be signed by the testator. Okay.
Which is the person that's passed away.
The person that's testating, right, to the will, before 2 witnesses. Okay. So 2 witnesses, in the presence of 2 witnesses.
Okay. I want to stop you right there as well. Often enough, we get people that are ill. And they're not in the right frame of mind, frame of health, condition, you know, excuse the lack of better words, but, you know, putting it in, they're not in the position to sign that will. What happens in that case?
So if you're not in the position to sign the will, let's say you're in hospital and you can't move your hand, or you can't write, you know, for whatever reason it may be, the formalities still comes into play, whereby you're allowed to make a mark.
I see. But also in
front of the 2 witnesses, but more so in the presence of a commission of oaths.
I see.
So that Commissioner of Oaths would attach a certificate
to say that
to
he's
attest
witnessed
that
it.
he's witness, and the mark on the will
Mhm.
is indeed the mark of the testator, or
Gotcha.
the mark the testator has made on that will.
Okay.
So yes, it can be done that way. Okay. Any other conditions you're referring to, let's say the person is in a coma.
Yeah.
Unfortunately, it's a difficult
Okay.
scenario.
Mhm.
Usually what would happen is, if there's a lot of time at hand, you'd appoint a curator
Right.
for that person, and the curator would then act on behalf of that individual that does not have capacity to act.
Okay. Right. So we've got our will. We've got our will signed in front of witnesses. We've got someone that looks after the will is appointed, is called.
So some of the other things that's included in the will. Firstly, your name,
Right.
your identity number, your place of residence, and your marital status.
Okay.
Whether
Very
you're
important.
married or not married, or widow, or you married in terms of Muslim rights, and if you married in terms of community of property or out of to have the name of your spouse there as well.
Okay.
Okay, and the ID number. Then you have to state that this is my last and final will and testament.
Gotcha.
Right?
Right.
And this will revokes all previous wills.
Gotcha.
Okay? Then the other part is you nominate whoever it is to be your executor.
Gotcha.
Right?
Okay.
So you can nominate more than one person as well.
As the executor, can it be a beneficiary of the will?
An executor may be a beneficiary.
Okay, got it. Okay,
Yeah,
so it can be a beneficiary. Okay.
Yeah.
In terms of the will itself, when someone passes away, how long is that will valid for?
No, the will always be valid.
Okay.
It will
Is there,
always be
there
valid.
isn't a
There's
certain
no,
amount of time?
There's no prescription or
Okay.
expiry date on the will.
Okay,
Okay.
brilliant.
So usually the testator himself has kept the will in safekeeping, maybe in a safe or in where he has all his documents, or he's asked the executor to keep it in his or her safekeeping, or alternatively, as he has asked his attorney to keep it in his or her safekeeping.
Right.
So at the date of death, that will then come out.
Okay.
And become a live document.
Okay. So with Wills Month being last month, are there costs involved? Can this, really cost somebody an arm and a leg? Is there an option where somebody can have this done up free?
Yeah, many, like for example, Wills Month, we're a bit late for Wills Month this month.
Right.
A lot of law firms were offering wills for free, drafting it for free. But if you're out of Wills Month or out of that period where that free option is available, a will can cost you anything between 750 Rand to 1,500 to 2,500. It really depends on your list of assets and how technical the will needs to be drafted, and depends, on your profile. It's important. If it's a straightforward one, it's quite inexpensive in that regard.
What happens in the situation where people are married in community of property, but the couple is estranged? For whatever reason, they can't find one of the spouse, gone missing, whatever, but they're still legally married. What happens in a possibility like that?
That is becomes litigious in nature, because once you're married in community of property, 50% of the estate is towards the other spouse, or the surviving spouse.
Right. Yes.
Now, if that surviving spouse has never divorced you and just left you, you can't find the person, then you need to approach the High Court. Okay. If you don't know of the whereabouts of this person, and you suspect the person may have died, for example, there's a special application that you make at the High Court, and that is presumption of death.
I see.
Right, so you've got to comply with those requirements. Right now, if the person has left you, okay, let's say 15 years ago, but you more or less know his whereabouts, but he hasn't divorced you, and you haven't divorced him, and because of whatever reasons there may have been, okay, that is also a process in court.
Okay. And also goes through the High Court?
Also goes through the High Court.
Right.
And if you don't know his whereabouts, that's another process,
Okay.
right, where you got to divorce this person and by way of substituted service. So the courts will then permit you to advertise in a local newspaper which you think his last place of residence was in that area and precinct or jurisdiction, to advertise in the paper or on Facebook or any other way the courts would allow you to advertise that you are looking for this person and there's a court date and you want is a case number and your intention is for a divorce to proceed.
Okay.
So that has to first be dealt with. The Masters is not going to listen to any other story like, oh yeah, I haven't seen him for 20 years, I don't know where he is. The Master is going to want a court order to state that you are divorced or there's a presumption of death or whatever other alternate relief you have seeking for a forfeiture of benefits or anything of that sort. The Master will look at that and accept that.
Brilliant. We're chatting to Advocate Yusuf Khan Dalwai. Our topic today, wills. It was Wills Month in September. The WhatsApp line 079 085 2511. You're welcome to send us any questions you have regarding wills. It is our legal slot, but we specialize in the topic wills today. We continue after the break. Do join us on the WhatsApp line and on channel 347. You are still tuned in to Hilaal Live. Welcome back to Hilaal Live. Very important topic today. It was Wills Month last month in South Africa, and we thought we'd carry it over and highlight some of the very important information that one needs to have in a will and the parameters around the will as well. In studio, Advocate Yusuf Khan Dalwai is educating us on this very important topic. Jazakallah so much for coming in and speaking about this, because it is rather important as well. On the WhatsApp line, we have the WhatsApp line open. This is your opportunity to be part of the show and let us know if you have any questions around drawing up a will and the parameters of how a will works. 079 085 2511. That's the all important. We're not taking telephone calls on this number, only WhatsApps. You're welcome to type in the full message. Try not to abbreviate and keep it to a minimum so that I can pose the question to Advocate as well. Yusuf, the South African law provides for certain parameters when it comes to a will. Does it provide a form of a verbal or oral contract or wishes when a will is drawn up?
Unfortunately, that's a very popular way that people would normally want to draft their will, you know.
Of course.
Saying, calling the family, okay, today I decide, you know, this one gets that one gets that. It's very, especially with the old folk,
yes,
you know, the previous generation. Unfortunately, those unwritten submissions or testimony won't be accepted.
Really?
In terms
not
of
allowed?
Not allowed.
So even like a video testimony,
no,
nothing like that?
It has to be in writing and you have to comply with the formalities set out in the will.
That's really interesting.
Yeah. So whatever your wishes are, whatever it may be, even if it sounds ridiculous, reduce it in writing. Simple as that. And make sure that you comply with the formalities of that will. The only time that the masters would consider an oral testimony is by if there's a dispute regarding a certain clause or provision in the will and there's an issue of interpretation, then the masters may look at what was the testator's intention. So the son would say, my father used to always say, you know, that this house must come to me.
Right.
And collaborate with the other heirs, and you know, and that is what it means. That is what that paragraph means, or that testimony means. So, but other than that, no.
What happens in the case where someone, for whatever reason, can't read or write? You get cases like that where people didn't go to school back in the day, you know, they can't really read or write. What happens in a case like that?
That person may appoint a representative, an attorney, to so that he can make his verbal testimony, right? And that
gets
person
documented.
will document it. read it out to him, ask him if he understands and appreciate the contents of this document, and then sign accordingly.
Gotcha. All right.
Before two witnesses. So that you can do.
We have the WhatsApp line open, 079-0852-511. Please send us a WhatsApp if you have any questions with regards to drawing up a will. The one question I think all our viewers are waiting for is Sharia-compliant wills. We know that that can be tricky in some instances. More importantly, how people are married.
Yeah.
That affects the will.
Yes. So in South Africa, our Muslim personal law is developing.
Right.
Because we're living in a minority country. And fortunately, the aspects of wills or estate matters was dealt with some time back. Okay. I'm not going to go into the different cases, otherwise I have to unpack each case. But the Master's Office accepts Muslim marriages insofar as those parties married to each other in terms of Muslim marriages and the surviving spouse in a Muslim marriage.
Gotcha.
Right? So that is recognized in terms of the contents of the will in a Sharia marriage and in a Sharia will or an Islamic will. Basically, what you need to do is you need to set your will up in such a way that your will, whatever it may be, has to be distributed in terms of Sharia, right? And at the time of or date of death, your will needs to be given to a Muslim body, right, or ulama body, and they would then work out the distribution, the percentage distribution in terms of Islamic law, in terms of Sharia. So at that time, because it's difficult to put in the percentage of your heirs or your children at the time when you draft it, because any one of them may predecease you. Then it becomes a bit technical. Right? So the alim would then look at who are the remainder heirs and then work out the percentage accordingly and issue a certificate, and the Masters then accepts it, and the liquidation and distribution account is according to that.
Okay. One of the questions that's come through on the WhatsApp line, I'm not sure if you're able to answer this. It says, Assalamu alaikum. I've heard about a tazkiyah will. Can you explain that?
I'm not fully familiar with it, but I can come back to you with that.
Okay, brilliant. We'll try and cover that as well. Shukr so much, caller, or on the WhatsApp line for sending us that question as well. So Sharia, like you said, our Islamic law is progressing. And there are various changes that will happen over the next, we're hoping, a couple of months, inshallah, as well. When we're drawing up a Sharia will, very similar to a normal will, what is the relevant information that one should put in there?
Exactly the same as a normal will. You've got to still comply with the formalities. Only thing that's different would be, it would be a paragraph that basically confirms that your intention is for your assets, for your estate to be wounded up in terms of Sharia.
Okay. Right? And especially in the case where you may have more than one wife, spouse, and children as well.
That's correct.
All of it needs to be documented.
Yes, all of that needs to be documented. And if it's not documented, whoever your heirs are is aware there's a one wife or second wife or children. That information gets provided to the alim who is going to be dealing with the certificate. So yes, so that is definitely an option for you. So there's no, in respect of Muslim personal law and estate matters, particularly estate matters, our law do recognize Sharia wills. So people should not fear that, we have to do it separately or differently. Whatever the terms of that Sharia will be executed and respected accordingly.
Okay, shukr so much for that. The estate itself, are there any particular taxes that needs to be considered? I mean, is there anything that a family needs to be aware of when the estate is starting to be wound up?
Yes, so there's cost involved, right? That is why it's important for you to consult with an attorney after you've done your estate planning, okay? Because it's important to make provisions for the expenses of the estate. If you don't make provisions for it, then your heirs will have to be responsible for the cost of the estate.
Right.
So firstly, you have 3.5% executor's remuneration that goes to the attorney for winding up the estate.
3.5%
of the total asset value of the estate.
Okay. Is that a fixed amount? Can that be negotiated?
It can be negotiated. Yeah, it can be negotiated, but it's a fixed amount.
Okay.
That's for the attorney's work, for attending to the winding up of the estate. It's a bit of a process, which we can unpack maybe in another program.
Of course,
because there's quite different avenues to it. And then the other expenses to take into account is the estate duty. Right?
If there's more than one property, especially.
Not necessarily more than one property. If your property asset value exceeds a certain amount,
right, you're liable to be taxed accordingly.
So you have an automatic rebate of 3.5 million rand.
Okay.
Right. So if your estate is worth 4 million rand,
the 500,000,
then 500,000 is what you'll be paying tax on.
Gotcha.
Right. So, and obviously the example can carry on.
Yeah.
So you got to take into account more or less what your asset value is and what your expenses would be estimated.
Right. Is there any fees that goes towards the masters?
The masters, there's a fee that needs to be paid towards the masters, but that depends on the value of the estate.
Okay. All
right. And there's other disbursement costs, for example, advertisements in the newspapers, in the government gazette. You got to pay, for example, a conveyancing attorney for the transfer of the property.
What about debt that's owed on the estate?
Outstanding debt, liabilities, whether it's a bond, whether it's credit cards, whether it's any other credit agreement that you've had, that forms part of the liabilities. So that the liabilities gets paid first, right, before
the disbursement happens,
gets distributed.
Okay. Yusuf, if people want to get hold of you, anywhere they can look you up, and if they'd like some of your legal advice, what's the best methods?
Yeah, they're welcome to look me up on Facebook. My full name, Yusuf Khan Dalwai. Alternatively, my mobile. I don't know if you...
We can always give it off air.
Yeah.
I think that's always the safer option.
Or they can just contact Hilaal TV.
There we go. You know, I always say, you know, when somebody has a double barrel surname, you take them seriously. Yusuf, Jazakallah so much.
Okay.
Really appreciate it. We look forward to next week's edition, inshallah.
Inshallah.
Have a great evening.
You too. Thank you for having me.
My pleasure. There we go. I hope that segment helped you understand wills a bit better. From the Cape Town studio, Sahel Barnes and myself, Luqman Shadrack. We're back tomorrow between 5:15 and 6:15, inshallah. Have a great evening. Assalamu alaikum.